Hello everybody, and a very warm welcome to everyone who's joining us today for this talk on Covid-19 and what it means for paid advocates and RPRs working in the Court of Protection. My name is Caroline Barrett. I'm a Senior Associate Solicitor in the Cambridge office, and I'm joined today by my colleague Emma Earnshaw, who's a solicitor also in our Cambridge office. But I know that we've got lots of people on our call today, which is great, and you're from all over the country. So although we're speaking to you from Cambridge, we do obviously have offices all over the country and can help out nationally. So the structure of today's session is that myself and Emma are going to try and get through as much information as we can to try and give you an update on what's been happening in terms of new legislation that's affecting our clients and the people that we work with, in particular in relation to the Mental Capacity Act and using the Court of Protection. We're going to speak probably for about 40-45 minutes in total, and we're going to try and leave about 15-20 minutes at the end to go through any questions that anybody has. We did have a few questions sent through to us when people registered for the talk today, but if you have any other questions that you would like to raise during today's talk, you should be able to go to the little black panel in the middle of your screen, which has a number of buttons on it, and there's a question and answer button on there. If you go on there, you can ask questions, and then at the end of the session we'll do our best to go through as many as we can. If we don't get through all of the questions, or if anybody has any other questions that arise, feel free to email them through to us after the talk and we will try to get back to you. Hopefully that all makes sense. This is the outline of what we would like to talk to you about today. We're going to talk about the Coronavirus Act 2020, which is obviously the new piece of legislation which affects some of the social care legislation, the social care duties for adults that we work with. We'll talk about do not resuscitate decision making, just because it's an issue that quite a few advocates have raised with us that they've had concerns about, affecting in particular elderly clients within care homes, and there's been some decisions made about that during this pandemic which people have not been very impressed with. So we'll talk about that later on as well. And then finally we'll talk about the practicalities of working in the Court of Protection during the pandemic, which is obviously affected, the way that we have court hearings, the way that we get evidence, the way that these cases are brought. So we'll try and talk you through some of those practicalities as well. Sorry, you have to excuse me, the slides go a little bit slowly. Here we go. So the Coronavirus Act, I'm sure lots of you will be aware of, came into force in April this year. The purpose of this act was to try, well, it actually applies to lots of different public bodies, public decision makers. The idea was to try and modify some laws during the pandemic to give public bodies a bit more scope and flexibility to apply the laws in a way that allowed for the fact that they were going to have less capacity to be dealing with everything. So particularly in relation to adult social care, the Coronavirus Act makes quite a few changes to how local authorities might want to apply social care duties during the pandemic. I think it's important to say, before I go through all of the changes that have been made by the Coronavirus Act, very few local authorities are actually using these amended duties at the minute. In fact, yesterday a couple more local authorities said that they were no longer going to use them anymore. So currently we only have 2 local authorities nationally which are using these so-called Care Act easements. So for all other local authorities, normal Care Act duties apply, but for Derbyshire and Solihull, they are currently using these Care Act easements. Nevertheless, I think it's really important that everybody is aware of what the Act says, firstly because other local authorities might enact them over the next few months, particularly, and we hope that's not the case, but particularly if there's a second wave of coronavirus. But also I think it's important that we're aware of them because, as I say, for local authorities that haven't enacted the easements, they have to continue applying the Care Act as normal. And so local authorities shouldn't be saying that they're not going to carry out assessments or not going to produce care and support plans, for example, unless that particular local authority has actually enacted the easements. So that's my caveat before I go through it all. But as I say, in essence, the Coronavirus Act allows for local authorities to exercise these easements, which will reduce the duties that are placed upon them. And the reason why these easements were introduced was effectively just to reduce pressure on local authority. There might be less carers on the ground. Social workers are going to be busy with all of the public health concerns, especially in relation to care homes and care provision. And so it's meant to allow some flexibility in how local authorities can prioritise care in their area. So we'll come on to how the easements are actually brought into force in a local area. However, where the easements do apply, then these are the areas of the Care Act which are affected. So in relation to a duty to meet needs, so currently in the Care Act, where you've assessed somebody's needs and you've identified that they have eligible needs which need to be met, a local authority has to meet those needs. Where the easements are enforced, that duty doesn't apply, so there isn't a duty to meet needs. However, the local authorities have a power to meet needs. And I should say, with all of these things, there is statutory guidance which helps local authorities interpret how to apply these easements. And the guidance makes clear that even though some of these duties are downgraded to powers, local authorities should be doing their best to meet needs regardless, and should only be kind of relying on this as a last resort. But the duty to meet needs is effectively downgraded to a power. In relation to care and support plans, where the easements are activated, then this suspends the duty for a local authority to prepare a care and support plan and to review and revise the plan as appropriate throughout. However, again, the local authority does have the power to make these changes, and they should still be involving P and their advocate or their family where appropriate as well. The duty to assess is removed and is replaced with a power to assess. And again, you know, from my perspective, this isn't a sort of get out of jail free card. Where this applies, the purpose of the easement is to give local authorities that flexibility to manage needs in their area. So where you have someone who's blatantly in need of care and support and the matter is pretty urgent, we would be expecting the local authority to still be using their powers to assess those people's care needs and to provide support to them, regardless of the easements. Wrong way. Charging for care and support. So as a result of the easements, the local authority wouldn't have to carry out a financial assessment. The result of that is that you can't charge somebody for care services unless you've actually carried out a financial assessment. And so the local authority wouldn't be able to charge for that individual person for their care and support. However, they could decide to charge retrospectively once the assessment is eventually done. In summary, where these easements are in force, we have a lessening of some of these duties. So we are reducing duties to powers in relation to carrying out care assessments, meeting people's care needs, unless there is a potential breach of human rights, I should add, in which case you would still need to meet care needs. The duty to carry out financial assessments has gone, and the duty to review those care and support plans over time. However, as I say, the statutory guidance makes it clear that this is a last resort. Local authorities have to properly justify why they are using these easements. And I think it's also worth saying that where we are in court of protection proceedings, local authorities often get ordered by the court to produce care plans or to provide evidence about how they would meet somebody's needs in a different setting. And the court can still order local authorities to provide that evidence. and we wouldn't necessarily rely directly on the Care Act in order to get that evidence completed. In terms of what doesn't change, all these things stay the same. So the duty to promote somebody's well-being, all of the safeguarding duties that apply under the Care Act, provision of advocacy, which of course directly affects all of you, that remains unchanged, and the requirement to involve the person in decision making. But it's fair to say that other than that, the Coronavirus Act does impact upon a huge amount of the other duties that are set out in the Care Act. So when does this all apply? When can a local authority actually operate the easements? The statutory guidance says that a local authority should only be taking these decisions where the workforce is significantly depleted or demand on social care has increased to an extent that it is no longer reasonably practicable for it to comply with its Care Act duties. And where, if it was going to continue to try and complying with its Care Act duties, it might result in urgent or acute needs not being met, potentially risking life. So I think it's fair to say that, the guidance makes it clear that this is very much a last resort. And what we saw when the Coronavirus Act first came out was quite a few local authorities rushing to implement these easements, some of which have been challenged with pre-action letters for bringing those easements into force. Some of them weren't, but in any event, quite a few of them have now stopped operating the easements and have gone back to normal Care Act duties. And as I say, we've only currently got 2 local authorities operating them. And I think that's because the statutory guidance does make it clear that it needs to be a last resort. Any decision to operate the easements has to be taken by the Director of Social Care in liaison with the Principal Social Worker, and it has to be properly recorded. And it needs to show, why it's the last resort, what kind of changes are going to be made, what the impact might be on people locally, and when it will be reviewed. So it's a big step to actually decide to operate these easements. But if a local authority does operate the easements, then it would need to fully justify it, as I've said, and set it out on a written record. It would need to notify the Department of Health and Social Care so that the Department of Health and Social Care can keep a record of which local authorities are operating the easements. It will need to, where necessary, record that they've considered that human rights wouldn't be breached in their area, and consider the ethical framework on the adult social care as well. So you'll have to forgive this slide, as I said, because this literally changed yesterday. So actually the local authorities using the easements as of today are Derbyshire and Solihull. Middlesbrough were doing it for a while, Sunderland and Birmingham, and obviously we previously had Warwickshire and Coventry as well. So we're down to just 2. I don't know how long Derbyshire and Solihull will keep it in place. I know that there is a potential legal challenge to Derbyshire's decision at the moment as well. So in terms of what you can look out for when you're supporting your clients, many of you will be acting as Care Act advocates as well as RPRs, and obviously it's important that people's care provision is up to date and is kept under review. So the things to be aware of is where local authorities might in effect be using the easements but without actually having activated the easements in their area. If a local authority is saying things like, well, we're not doing care assessments at the minute, or we're not reviewing people's care plans, or we can't provide funding for a different placement at the moment, it can only be doing that if it's actually operating the easements. It can't operate the easements without the council itself having formally put them in place. So just be alive to that. If you're working in a local authority area where the easements aren't in force, the Care Act should apply as normal. And as normal, we still have, where there's potential discrimination, there could be breaches of the Equality Act, potential breaches of human rights if local authorities are failing to comply with their duties, and clients should still be involved in all of the decision making that's made about them. Where local authorities aren't relying on the Coronavirus Act, they don't really have any excuse for not complying with the Care Act and all the statutory guidance that comes with it. Just to say, These slides will be coming out to everybody afterwards because we're going to be doing a recording of this session, and it'll be coming out to everyone, and we've included there a link in case any of you want to have a look at that guidance which local authorities should be following in relation to operating any Care Act easements. Moving on to Do Not Resuscitate, this rather pithy acronym DNACPR is Do Not Attempt Cardiopulmonary Resuscitation. We've had quite a few advocates raise concerns with us about some decisions which have been taken around Do Not Resuscitate since the pandemic took over all of our lives. Most of you will be aware that in particular at the beginning of this pandemic, there was quite a lot of press about some quite concerning decisions that were being taken in local areas. So, for example, GPs writing to groups of people with a certain diagnosis saying that they were going to put Do Not Resuscitate notes on all of their records. So some quite blanket decisions being taken about when to operate Do Not Resuscitate orders. And so we thought we'd just kind of explain briefly what some of the things you might want to take into account are when, if you discover, for example, that one of your clients has a Do Not Resuscitate order on their records and what it might mean. So the purpose of the Do Not Resuscitate decision is to provide immediate guidance to those present on the best action to take should the person suffer cardiac arrest or just generally need to be resuscitated. In the majority of circumstances, if somebody is found unconscious, in the street, they're going to be resuscitated, but particularly where they have an ongoing health condition or they're in hospital for quite a long period of time, medical staff might consider whether it's appropriate for that person to be resuscitated if they were to fall ill again in the future. And so a Do Not Resuscitate order is where a doctor issues and signs a document which is effectively attached to somebody's medical record or is digitally on their notes on the system, which sort of tells the medical team not to attempt CPR on a particular individual if they were to have a cardiac arrest or stop breathing. It is a clinical decision, so it's not technically a best interest decision. It's a decision taken by doctors about when it would be appropriate to provide that medical treatment to somebody. And as a matter of law, you cannot force doctors to perform a medical intervention where they don't think it's clinically necessary and where they wouldn't provide it otherwise. So it's not technically a best interest decision, it's a clinical decision. And it's normally put in place if the clinician considers that either it will be futile to attempt the resuscitation or it wouldn't be in the patient's interest because they wouldn't survive it or they wouldn't recover from it, or it would cause more damage if they were to recover than it would solve. And I think it's worth saying, and I'm sure most of you are aware, but I think the CPR that we see in medical dramas is very different from the CPR that's actually performed in hospitals, which can be very invasive and actually quite violent and can cause, broken ribs and things like that. So for elderly people, there are clinical decisions sometimes not to resuscitate individuals if they were to fall unwell. Now, what the law says about these Do Not Resuscitate orders, before I get on to that, we just thought it'd be helpful to clarify why that's different from an advanced decision, because this is something else which comes up quite a lot. So an advanced decision is a decision that any of us could make now to sign a document to say that in the event that we fall ill, we don't want CPR to be performed on us. And lots of people make these advanced decisions if they've decided that if they were to suffer, a severe car accident or a severe brain injury, that they wouldn't want to be resuscitated. And as long as you fill that, as long as you follow the procedure for that, so you put it in writing, and if you're refusing life-sustaining treatment, it's signed and witnessed, that is a legally binding document. So if you have that on your records or on your files, then doctors wouldn't resuscitate you because that's your wish not to be resuscitated, even if they thought it was clinically viable, because that's your decision. So that differs from a Do Not Resuscitate order, which is a decision that's actually taken by the doctor themselves. So looking at the law around the Do Not Resuscitate orders, it is mandatory for doctors to inform the person to the patient, that they will be putting the do not resuscitate order in place and to discuss the reasons why. And this is obviously where that person has capacity to understand it. And where that person or the family then objects to that do not resuscitate order being put onto their notes, they can try and seek a second opinion or potentially challenge it if they think it's actually unlawful or discriminatory in some way. But there needs to be transparency about these orders being applied to people's notes. Sorry, these slides go very slow. And where somebody lacks capacity, then the doctors would need to consult with anybody who's closely connected with them. So it could be deputy, it could be the family or close friends. And for somebody who doesn't have family or close friends, if you are involved as an advocate, then you are somebody who should probably be consulted as part of that. And again, it's not to be consulted as insofar as it's a best interest decision, but it's to understand what wishes might be around the do not resuscitate order and to be transparent about it, because if there is disagreement with that order being in place, it's important that people know it's there and a second opinion can be obtained or legal advice can be sought as well on the do not resuscitate order. So the recent concerns, bearing all of that in mind, the recent concerns that have come up about this are about blanket do not resuscitate orders being applied to people who might live, for example, in a care home setting or have dementia. As I said, there were some examples of that happening at the beginning of this pandemic, where sort of mass letters were being sent out by GP surgeries. And clearly those types of decisions would be discriminatory because you're making a decision based purely on somebody's diagnosis and not on their own personal clinical profile and whether it's appropriate for them to be given CPR or not, and they're not being consulted about it either. So all of those kind of blanket decisions that were being taken were not right. And similarly, some decisions were being made without people knowing or without family being involved. And all of this leads to potential human rights breaches as well, if blanket orders are being applied in this way. And to try and clarify some of that, the Department for Health and Social Care issued some guidance in April, on the 15th of April, in which it made it clear that it is unacceptable for advanced care plans, including do not attempt resuscitation orders, to be applied in a blanket fashion to any group of people. It must always be a personalised process. So doctors or carers should be consulting with people who might be approaching end of life or who might become unwell and asking for their views. And if doctors need to take a clinical decision about do not resuscitate, then it needs to be done on an individual basis and not in a blanket fashion. And so in terms of what you can do as advocates about that, hopefully that gives you a bit of a summary about what the law says about do not resuscitate orders. And if you are working with an individual who, when you're going through their records, for example, you find they have a do not resuscitate order in place, you might want to be making some queries about whether family was involved, whether your client was informed about it and how that decision was made. Because if it was part of some sort of blanket decision, or if you have concerns about whether it's lawful for there to be a do not resuscitate order in place, then you can either make representations on that person's behalf and seek further information, or you can, of course, seek legal advice on their behalf as well. And finally, we just thought we'd put a slide in about hospital treatment during COVID-19 as well, especially at the outset of this pandemic. There was a lot of concern from the NHS about capacity within intensive care units, and there's been a prioritising of care, so how doctors plan to prioritise care for people who might need it in intensive care. And again, none of this is without controversy. What ended up coming out was this framework called a clinical frailty scale, which was meant to be a guide for clinicians as to the level of treatment that they should provide to people where they need to prioritise their resources. And effectively, depending on your pre-existing health conditions, for example, whether you're mobile, whether you have lung disease or COPD or diabetes or whatever it might be, you were kind of placed on this sort of frailty scale. And the kind of higher up the scale you were, the less likely it was that you would be intubated on ITU. So that frailty scale has been subject to various bits of legal challenge. Currently, it only applies to people over 65. And I'm flagging this because, again, I think there are concerns when you have clients that might be taken to hospital with COVID-19. Myself and Emma have had a couple of clients taken to hospital with COVID-19. Whether it's appropriate for them to be discharged without receiving treatment. This scale, this frailty scale, is in place, and this might explain some of the decisions that are being taken about whether to provide them with treatment or whether to discharge them back to their care home without intervention. But it's important to note that these types of scales, again, shouldn't be applied in a blanket fashion. There can be cases where somebody might be quite high on the frailty scale, but they're currently quite fit and healthy, and the doctors decide that they're going to provide treatment anyway because they think they've got a good chance of coming through it. So doctors should always be willing to kind of deviate from the scale where it's appropriate. And also, we are aware, obviously, at the minute that there is capacity within ITU. We're told, certainly by the government, that there are spare beds. And so the extent to which doctors are currently relying on the frailty scale is a bit unclear at the minute, because I'm not sure they're actually having to follow it as much as we initially thought they were going to have to, because there's plenty of capacity within ITU. But those are some of the things that we just wanted to make you aware of in terms of the legal updates around Coronavirus Act, do not resuscitate, hospital treatment. Hopefully that gives you brings you a little bit up to speed about what's been going on in the realm of health and social care law. I'm going to pass over to Emma now, who's going to take us through the practical procedures of working in the Court of Protection during the pandemic.
Hi everyone, thanks Caroline. We wanted to talk to you a bit about the Court of Protection, what it does in normal circumstances, and also how that's changed as a result of the pandemic. Largely in terms of practicalities. This slide, I'm sure you'll all be very aware of in your own roles. But really what I take from this slide is that advocacy at the moment is more important than ever. There is a limit as to how many professionals are able to go into care homes and to CP at the moment. And that in some ways puts more importance on advocacy to make sure that those people's views and well-being are still protected. You'll know that independent advocates are classed as key workers, and that advocacy services are continuing to operate, albeit in slightly different circumstances. The final point on this slide is worth noting, and something we'll talk about in more detail shortly, in that we're still issuing Court of Protection cases, so whether they're Section 21A, people objecting to their doles, or whether they're Section 16s and issues need to be determined in someone's best interests, those are still being issued, and we're still taking on cases of those nature. So the next slide, please, Caroline. Thank you. The next couple of slides is just a recap about bringing Section 21A proceedings, and I'm going to talk really in the realm of normal life as opposed to pandemic. And after that, we'll talk about how these things may change and how things on the ground have changed as a result of the current situation. So you'll all be familiar with Section 21A. So proceedings can be brought to the Court of Protection under this section when somebody is subject to a urgent or standard authorisation, who is doled effectively in a care home or a hospital. They have the legal right to a review by the court. The court will be looking at the terms of that authorisation, whether it should continue and whether any of the terms should be varied if it should continue. One of the RPR's key roles is clearly to consider P's wishes in this, and the authority on that in terms of the case law is the RD case, which provides guidance in terms of what the RPR should be considering when bringing a Section 21A case to solicitors and then subsequently to the court. I've just outlined the guidance on the next couple of slides. So the first question an RPR should be asking themselves is, if P is objecting to the DOLs, do they have capacity to bring legal proceedings? Particular thing to note here is that there is a lower threshold for capacity to bring legal proceedings than there is to conduct proceedings. So it's possible to be able to bring them and then need a litigation friend later down the line to actually help conduct them. So again, these questions should all be considered. Does P understand that they should not be subject to their current care arrangements? If P has capacity to ask to issue proceedings, those wishes should be followed. So ideally, that's when an RPR would get involved and discussion with a solicitor. This slide, I suspect may be more relevant to a lot of you in the course of your work with individuals in care homes, and that's a situation where it's highly likely that that individual lacks capacity to issue the proceedings. So these are the 4 steps that as RPR you'd need to be thinking about, because it's still important to consider whether P would want this issue to be brought to court. The first box just on the left hand side there looks at whether P has expressed a consistent wish to apply to court. So in usual circumstances that would come around you having visited P, having had a conversation about P, and taking statements, taking stock of your previous RPR reports, looking at the frequency of objection and consistency of that, and if there's any other aspects of their care or their condition that might impact their wishes or emotional state out with that, and weighing up based on their wishes that they've communicated, do you think that they would wish to apply to court? If it's not possible to ascertain that in that way, the next thing to do is look at P's behaviour. So does P's behaviour indicate they would wish to apply to court? So for example, have they packed their bags? Have they tried to leave the care home? Have they consistently told carers they want to leave? Are they exhibiting any challenging behaviours which aren't necessarily linked to any other presentation or circumstances around them? And again, that, you know, it's appreciated that can be difficult. So the third step to consider, if neither of the first 2 are possible, is whether P would likely wish to apply to court if able to express an informed view. This is where solicitors and RPRs can have some discussion, and it's where looking at records and previous DOLS documents and RPR reports can be really helpful. Ultimately, though, if you struggle to get P's views as to bringing proceedings, the RPR should take a step back and consider whether they think it is in P's best interest to bring proceedings. So do you consider that P does not meet one or more of the qualifying requirements? Is there a period of authorisation that's contrary to P's best interests, or are there conditions which are contrary to P's best interests? Or can the purpose of the authorisation be as effectively achieved in a less restrictive way? And if the answers to those are yes, then that's when you would need to seek legal advice on their behalf. So following on from that then, in terms of what your role is and what to do if you think P is objecting, again, I'm talking about the pre-coronavirus situation here. So if you can visit P more than once to ascertain views at different times and look at the consistency of wishes and record those in your reports, because that's something we will need when we apply to the court to evidence that P has said this on more than one occasion. It's worth noting in the box below that I've outlined the paragraph in the Code of Practice that allows RPR access to P's care home records, because you do have a right to obtain those, and it can be useful to look through those if you're not able to get a direct answer from P when talking to them. The other points are just to make sure your RPR's reports are up to date as possible. And another point that we need to look at, and we will look at in the future slides, is to ensure you have a copy of the standard authorisation, and if it's expiring shortly, make sure the local authority is aware, and when solicitors like ourselves get involved, we do flag to the local authority that P is objecting to their doles, and we do seek to have the authorisation looked at as soon as possible before it expires. So the next slide is in relation to whether there's any potentially quicker resolutions for P. So these shouldn't preclude an application being brought, because P has the right for their objection to be looked at by the court. But practically, it's worth considering whether there are alternatives. So is there a way to agree a way forward with the local authority or family? Could you suggest a meeting? And would a Part 8 review of the doles be appropriate? As I say, court applications and court proceedings can take several months sometimes, depending on what the issues are. So it's always worth trying to resolve things as quickly as possible, if not before contacting solicitors, then at the same time, to try and make that process as efficient as possible. So the next slide then is following on from the coronavirus and the impact that this has had on the Court of Protection. Now, I just wanted to input this slide here because I think it's an important point made by Mr. Justice Hayden, who's the Vice President of the Court of Protection, and he effectively notes that nothing has changed in relation to the Mental Capacity Act and the Court of Protection rules, and that nothing has changed to the fundamental rights and freedoms which underpin them. He notes the importance of these in relation to vulnerable people, and in other sort of webinars that I've been on that he's been talking at, he's keen that these cases are still brought before the court when there are questions of what's in P's best interests, despite the current situation. Here, I just wanted to touch on a question that we had before the webinar, and that was in relation to the impact on timescales in terms of the proceedings and applications being brought to the COP in the current circumstances. So generally what we're seeing is we're able to issue cases, and hearings are listed in a normal time frame that we would usually expect. The delays are coming, at least in my cases, when assessments are necessary. So when an expert needs to see P face to face, or capacity assessments need to take place and it can't be done remotely because P wouldn't be able to cope with that on a communication level. So there are some delays creeping in, but on the whole, the Court of Protection's able to manage these cases very well. And, you know, usually when you issue a Court of Protection case, when you make the application, a hearing should be listed within 5 days of that. We don't always see that, but the court are proving a pretty efficient turnaround time despite the current pandemic. As I say here, this is talking about Section 21A proceedings, and Mr. Justice Hayden there again saying that there has been a drop in the number of Section 21A applications. Now, I think he said that at the beginning of April, so I'm unsure as to what level the applications are on now, but the message here really is if there are any of your clients who are objecting, it's the pandemic shouldn't preclude you from seeking advice for them if in relation to taking that appeal to the courts. The final bullet point on this slide here is relating to the practical considerations, what changes because of the pandemic. So this is a list of things which are different. I'll very quickly run through these. So hearings are going ahead remotely by either those means that are listed there. That depends on the local court in most circumstances. The open justice principles apply, so hearings are open to journalists, as they usually are, and they're able to attend remotely, although there are injunctions in place to prohibit reporting on some matters. Cases are still being issued by the COP, as I've said, And there is a focus on encouraging parties to agree directions prior to hearings. Now, that's not necessarily a new feature due to the pandemic. That's always been something that's encouraged, and something that we certainly try and work with in our own cases. In terms of the practicalities of getting papers to the court, to the judges, to the parties, that's all being done electronically, and experts are still being able to work and file reports and conduct remote assessments where they can, although, as I've said, that's not always possible, and it's really has to be looked at on a case-by-case basis. The final point here I just want to spend a couple of minutes on, because obtaining P's views from RPR advocates' perspective, this is where I've been speaking to advocates and they've been finding it a challenge, which I don't think there's any denying it certainly is. What we would suggest is looking at different ways that we can speak to P. So first of all, you need to think about how to access P, and that's changing with the government guidance. As I say, if you can FaceTime, video call, telephone call, that should certainly be trialled. The other thing is, if you're not able to speak to P directly, review the care records, recent reports, any assessments. And for our purposes, if we are taking a case on, it's helpful for us to be reviewing recent RPR reports. It's worth noting as well that some social workers are able to see clients, and in some cases they've been able to help record their views for the purposes of bringing a court protection matter for them. You can also speak to carers and speak to family members to get a better idea of what P wishes. Now, clearly there's a worry here that there's risks to P's health. We've seen huge percentage increases in the number of deaths reported in care homes by relating to learning disabled individuals, which is quite frankly startling and really worrying. We've put this slide in place because in our own practice we have come across issues where P's placement does have Covid-19 within it. This is guidance for the RPRs really on a practical level. So what you can do is check that the care home is responding to the risk appropriately. So are they following the current public health guidance? Are they using PPE? And are they limiting or prohibiting visitors appropriately? If you're concerned that any of those things aren't being done or aren't being done consistently or efficiently, then you can raise these concerns with the local authority. The other aspect that you might want to consider is whether P is able to move to an alternative setting. So within this consideration, you need to think about whether there is a family member who would be able to support them. If COVID is live in a placement and there is an alternative, that will be looked at quite heavily when we're looking at best interests, and that doesn't necessarily have to be within the court protection. That could be a best interest decision that's made by professionals on the ground. I've included a note here as well, just to flag that there isn't anything stopping P moving during the pandemic. So there is a circumstance where they could move to a different care home, but it's very dependent on the current situation, and it's always going to be a best interest decision. The other question we had in relation to risks to P's health was regarding the court protection's potential involvement in COVID testing within care homes. That's not really something the Court of Protection is involved in or can be involved in, but it's down to each individual care home. And I understand there's an online portal that care homes can access to request testing kits to their specific homes. And that applies to both residents and staff. So if there are issues, which we have heard there have been with certain care homes, it needs to be flagged with that specific care home, and I suggest that the online portal would be a good place to start. So the next slide here is another practical consideration which we need to take into account when we're looking at issuing a case. We can issue a Section 21A case when a valid standard standard authorisation is in place. Now, currently, there are challenges in best interest assessors and Section 12 doctors going in to carry out further assessments of P in the care home in order to put those authorisations into place or to put them before the court. It's worth noting that once in the Court of Protection, once a case is live, the judge can vary the standard authorisation for 12 months, for up to 12 months from its start date, but any longer than that will require reassessment. The standard authorisation needs to be in place for P to be eligible for non-means tested legal aid. So it's really important that it is in place so that we can keep representing them. The practical things that we can do is keep an eye on when those authorisations are set to expire and request the local authority reviews these as soon as possible and flag it to them as soon as possible that these will need to be reviewed. The other practical thing that can be done is to try and keep the authorisations in place for as long as possible if the COP matter is being heard, so extend it where possible to give us that leeway to continue to act whilst P can't be visited in person. As I say, there may well be some more guidance which comes out relating to this, because I know that the courts recognise that it's a roadblock to people being able to obtain representation and maintain representation as well. So with all the issues that we've mentioned in today's webinar, if you're in doubt, contact a solicitor and we'll be able to give you a brief steer as to where might be best to aim your questions. Not sure that Harvey Spector will necessarily be available, but we will be. We've also included some online resources here. The top one is particularly useful because it's an easy read guide for vulnerable adults about coronavirus and explaining it in simple terms. The only caveat I would add is obviously the government guidance is changing quite frequently, and I think this particular link relates to the April guidance, so it might be worth just checking as new guidance comes out whether this is being updated as well for those for the people you work with. There's also a couple of other guidance links there in case you want to read up on any of the issues we've discussed a bit more. This is our Irwin Mitchell website, the Coronavirus Hub. So I believe that there's updates as to the coronavirus every couple of days on this website. So feel free to check every now and again what's going on, and we'll try and put out as much information as we can. So now we will move on to some questions, and if you do have any questions after the seminar, feel free to email the events team and we will try and get back to you. I know that a few questions have come in whilst we've been talking, so if it's all right, I'll hand back to Caroline and we can try and address your questions together.
Right, hopefully everyone can hear me again. Perfect. So we've had a few questions that have come through. I'll do my best to answer them. So let me have a quick look. So we've got someone who said that they've got a client who has dementia, no comorbidities and is fit and able. They are challenging this with the GP. I presume they mean a do not resuscitate order. Are they right in doing it? No advance decision in place. Yeah, I mean, I think it depends. Obviously, if you have a client who's got family members and the family have been consulted, and you know, we think P may have been consulted, that's one thing. But if you are the client's only voice and you're not sure that anybody's been consulted on their behalf, then I think it's the right thing to do, personally, for you as their advocate, to make sure that that decision is being taken appropriately. And if you are struggling with the GP or struggling with getting any information about how that decision has been taken, then it's possible you might be able to get some more information off the care home or from the local authority themselves. And I don't know who's asked that question, but if you're struggling or anything with that and want a bit of a pointer, drop me a line after this and we can speak separately about that one. Someone else asked, is Aintree v James still the key case law on do not resuscitate? So Aintree and James addresses the question of when medical treatment is futile. So that feeds into, you know, when do not resuscitate orders are made, because obviously one of the decisions is if a clinician thinks treatment is futile. So Aintree and James sort of says things like it's not going to be futile if somebody isn't going to recover fully. You just have to recover to a quality of life that they would enjoy, and that's how you can look at futility, for example. So that case does cover the issue of futility, but there are other cases that cover do not resuscitate orders in a bit more detail, and the main one that we tend to look at nowadays is one called Tracy. So I think it's Tracy versus Cambridge Hospitals NHS Trust, and that was a case that was brought where a family challenged a local authority, sorry, an NHS trust for having placed a do not resuscitate order on a family member without their knowledge. And so that sets out some of the law and the considerations in relation to do not resuscitate orders. Someone else has asked that they thought that in relation to whether it's in P's best interest to bring proceedings, that RPRs were specifically told not to make best interest decisions about bringing proceedings. Yes, sorry, it's a kind of nuanced point, because whether to bring that the RD case concerned whether there should be some sort of best interest question about whether to issue proceedings on P's behalf. And the issue was raised by local authorities who, for example, were saying, well, you know full well that this particular person needs 24-hour care in a residential home. It's not proportionate to keep bringing proceedings on her behalf when you know what the outcome is going to be, and should you not be asked whether it's in her best interests to bring the proceedings, even if she's objecting. And the court has sort of clarified that it's no, you don't need to have a best interest threshold. And so the questions that you ask yourself are not whether it's in P's best interest, but it's whether is P objecting. Do you think that P would object if they had capacity to object? Do you think that P would want to go to court if they had capacity to understand about going to court? And those are all the things that Emma went through. But the final question is for the RPR themselves. That if you think that P isn't objecting at all and P is actually quite happy and content and doesn't seem to be exhibiting any wish to leave, for example, but you as RPR have seen her records and you're really, you know, you might be concerned about the care that she's getting there. You might be concerned about the way that she's being treated, even if P themselves is not objecting, then you as RPR could make a decision that you think it's in their best interest for you to bring the proceedings on their behalf anyway. And you as RPR could be the claimant if you wanted in those particular circumstances. It doesn't necessarily have to be P. So it's a bit of a nuanced point, because no, there isn't a best interest threshold about bringing these proceedings. Where P objects or you think it's right for the proceedings to be issued, then they can be issued. It's just that RPRs can also ask themselves a question if they want to bring proceedings, even if P isn't objecting. Hopefully that makes sense. Somebody else has asked that they've got a client who wants to leave, bags packed, shouting, saying she wants to go, but she will not engage with the RPR or the solicitor. So the case has been dropped. Is that right? But I don't really want to kind of comment if another solicitor is involved or if they've taken a decision, because I don't know the full circumstances. But in general terms and in theory, that wouldn't necessarily stop you bringing proceedings. I wouldn't have thought, because the question that you would ask yourself in relation to the RD case is whether you think P would want you to have brought proceedings if they were able to properly express that view, for example. So if you're satisfied that P is objecting and would want to challenge that authorization if she was able to kind of understand that, then that's the kind of threshold question really about whether proceedings should be brought. It's obviously very difficult if P then doesn't want to engage at all, but I think you'll probably find that the threshold is met and that the court could decide how to then treat the case and how to take it forward. If anyone has any specific questions about that, again, then obviously just drop myself or Emma a line afterwards. Someone else has asked, are there any delays to COP applications regarding signing or ending tenancies on behalf of people who lack capacity? If not, what would be the timescale? I mean, if it's a standalone, to be honest with you, we don't often do standalone applications that relate just to tenancy agreements, because often what happens in mine and Emma's cases is that the issue about who can sign a tenancy comes up in the context of wider welfare considerations that we're looking at. And in those circumstances, then no, we don't really have any delays to it, because it's all dealt with at the same time, and our welfare cases are proceeding through the COP as usual in most circumstances. I have heard from some people that there is a bit more delay where you're sending one-off applications to the COP on a purely paper basis. So some of the financial applications and possibly some tenancy decisions. So there may well be delays, but because I don't often deal with them on a standalone basis, I'm not sure of the exact answer to that. But it's just, if it's urgent, it'll have to be expedited. So if you put in an application to the COP on something like that and you don't hear back, if there is genuine urgency to it, i.e. the person needs to move next week, you can put in an application for expedition and get it sped up. As an RPR, we are always told that we don't have a legal right to look at care files, and this is backed up by the local MCA team. Well, I mean, I think Emma's already sort of set out in her slides. I mean, it's in the code of practice, and you do. And I mean, I think it's worth saying, see, some local authorities in some areas, you know, pick up some, should we just say, sort of bad practices. I mean, the practices around here of our local authorities are that our RPRs, I don't think, have ever been told they're not allowed to see the records. So there might be some, you know, particular areas where the wrong message is being given. But as a general point of principle, you know, no, you should be able to access somebody's care records when you go and see them in the care home. Even if they don't send them to you, you should be able to just inspect them while you're there. Yeah, you should be able to have access to them. And finally, someone's asked, please explain how do not resuscitate is a clinical decision and not best interest decision. I mean, I've just mentioned the Tracy case, actually. If anyone wants to kind of read the judgment, I mean, I know obviously reading judgments is a bit boring sometimes, but actually it's very helpful in relation to do not resuscitate, because it kind of explains why it is in there. There's always been this kind of uncomfortable overlap between clinical decision making and best interest decision making, and the Aintree case also confirms that we cannot compel doctors to provide treatment which they aren't willing to provide. So it's up to a doctor to decide what treatment they are willing to provide to you, and you can't compel them to provide treatment that they don't think is clinically appropriate. And that's why certain things are not best interest decisions, because even if you said it was in someone's best interest, if a doctor thought it's not clinically appropriate, they wouldn't provide it. Now, in some circumstances, you can judicially review a clinical decision, but it's difficult because obviously you have to show that the clinical decision is unlawful and that the doctor hasn't somehow complied with appropriate protocol when making that decision. But there is a legal difference between clinical decision making and what is up to a doctor to decide and what's a best interest decision. And you can compare it as a parallel to things like when we look at in our Section 21A proceedings, when we're looking at where somebody should live, we can only look at what the available options are. So we could never have a best interest decision which said it's in P's best interest to go home if home isn't a viable option, if there isn't a viable care package, if home's not there, because a best interest decision can only look at what's actually available and what can actually be provided. And if a doctor is saying, I'm not going to provide it because I don't think it's clinically appropriate, a court couldn't order it and say it's in their best interests. So it has to be what's available. Right, we've done the questions just in time, so it's 2:59. Hopefully that answers any questions that you have. If there are any other questions that we haven't answered, obviously you can email myself or Emma. You can also email the events team. So this screen here, events@Irwin Mitchell. and they will direct your queries to either myself or Emma, or perhaps your relevant office, depending on where you're based in the country, and one of our colleagues will be able to get back to you. So thank you very much to everyone for attending today. I think you will be sent out a recording of this session, and you'll also be sent some opportunity to give us some feedback. We always welcome any feedback that you want to give us on this session, and also if you have any ideas for other webinars that you would like us to hold that would be useful to you as advocates, then please do let us know and we'll take that into account. Thank you very much.